Camera roll.
All right, cool. Well, Lindsey, tell me, how would you like your lower third to be presented? What do you want as your title?
Executive director would be good.
Okay. All right. Cool. So we are 20 some odd years after Atkins. Can you talk to us a little bit about where we are and how the legal landscape has changed since Atkins?
So I graduated from law school and started doing this work probably about 10 years into Atkins. I graduated in 2012, so I've only really seen the second half, though I have studied the statistics on Atkins over the years. I think we're at a point where we've had the people who were most obviously intellectually disabled and on death row have been removed from death row. That happened pretty early on after Atkins. Now we're at the point where it's coming up in new cases that are being brought by prosecutors, and defense attorneys are acknowledging and recognizing in their investigation that people have intellectual disability. So it's being raised before trial and has become part of settlement negotiations or reasons why prosecutors might not be seeking the death penalty. And then we're seeing there are some older cases that are still on people on death row who have legitimate Atkins claims. And we're seeing, I think, a lot more struggle in finding a procedural way to get the merits of those claims decided by the courts.
So what are some of the challenges that you see that attorneys face? I know we were talking with Emily about specific things, and but what are some of the challenges that you see that are consistent across the board when we talk about this issue?
I think one of the biggest challenges is that if intellectual disability is missed by any set of attorneys along the way, whether it's at trial or in state post-conviction, it becomes harder and harder to raise that claim and have a court actually fully consider the merits of the claim. We're seeing in federal habeas, it's almost impossible to present new evidence now, and so there is a lot more challenge to getting it before the court. A lot more work has to be done by the attorneys to try maybe and get back to state court to have the state courts be the first adjudicator of the intellectual disability claims.
Is that because of this idea that, or maybe not an idea, but because the courts are more concerned with proceduralism rather than really focusing in on whether or not this person legitimately has ID? I mean, what's your take on that?
Yeah, I think in a lot of the cases that I read, that is the struggle that the court is having. What procedural mechanism are they trying to use? Is that a valid procedural way to get this before the courts? The states are raising procedural challenges to even having the intellectual disability claim adjudicated. And so rather than get to the merits at all, we're seeing the courts stop short of that and are often just looking at procedurally, is this a claim that can even be raised and litigated at this point?
Okay. Yeah, it's unfortunate. So tell me, what are you hearing from your colleagues across the country when they're faced with a potential Atkins case? What are some of the things that seem to be, consistent as far as what comes up when they reach out to you, talking to your colleagues across the country?
I think some of the main issues that are coming up are, how do I go about investigating this? How do I get the court to provide the funds, the resources, the time to be able to fully investigate and present the intellectual disability claim? I think the courts don't fully understand that it takes a long time and a lot of work to develop an Atkins claim, and that it is really truly necessary in cases. And so I have received calls about, how do I convince my judge to give me more funding? How do I convince the judge to give me more time so that my expert can complete the evaluation? And so we have helped attorneys and trial teams really educate the courts on why it's really important to do this work and why it is so involved. It's so detailed and focused on the client's entire life across the entire kind of the different spectrums of their life. You have to look at their work and their school and their developmental milestones. And so there really is a lot more investigation into an Atkins claim than there might be even a mental health claim.
I'm going to ask you to say that again because we
Sure.
have a loud.
Gotcha.
Yeah. So let's talk about what are some of the things that you find becomes top of mind for some of your colleagues, some of the challenges that they face.
I would say a lot of legal teams have a hard time or are finding a challenge with the courts giving them the time and the resources to be able to fully investigate and litigate an Atkins claim because they are so intensive on the investigation side, the expert evaluation side, bringing people in to be able to present that to the court. And so we work with a lot of teams to work on educating the courts for why this is all necessary to be able to litigate the claim and certainly why the claim itself needs to be raised.
It's got to be challenging here.
Yeah.
So let's talk about some of the common myths or stereotypes and stigmas that people have about folks that have ID. What are some of the common things that people say, or some of the things you've heard about that are perceived in courts?
I think one of the main things that I have seen in the cases that I have litigated is a stereotype and a belief that people with intellectual disability can't learn anything. And so the state or the judge might think, well, if somebody's able to progress at all through school, if they're able to accomplish anything that seems academically related, then that means they can't be a person with intellectual disability. And so it's a lot of work on the side of the defense teams to be able to educate people that that's just not true. People with intellectual disability, especially mild intellectual disability, which is usually what we're looking at, can accomplish a lot, especially if they have supports. And so we do a lot of work to identify the supports and the people who are making it so that our clients can accomplish things in order to explain, this really is a person with intellectual disability and here's how he was able to accomplish, whether it's graduate, whether it's get a GED, have some sort of job. Usually there's some sort of support that is helping them do that.
Okay. Now you mentioned mild intellectual disability. Can you talk about that a little bit? Because I think a lot of people may not understand what mild intellectual disability is. They may not understand that, do we have, what's that?
Actually, yeah, that's a good
Change
stop
the card,
over. Yeah,
change the
go change
card,
the
oh,
card. Okay, rolling.
Okay. Yeah, the mild intellectual disability, a lot of people may not understand what it is. They may not understand that, we have I guess you have the data that possibly shows that there are a lot more people across the country that operate in that borderline or mild area of intellectual disability than we think.
Mm-hmm. Yeah, so mild intellectual disability is people kind of at the higher end on the IQ score range, but still falling within the intellectual disability range. And then people who are higher functioning in the adaptive functioning area. It's much harder to identify a person with mild intellectual disability for a couple of reasons. One is that we have stereotypes that people really can't function at all with intellectual disability. And so when somebody is higher functioning with intellectual disability, it's a little bit harder to identify. But also there is such a stigma around having intellectual disability that people who are higher functioning find ways that they can mask the fact that they have disabilities. They can do that through having family to support them. We've had clients who have trouble reading but know that there is a shamefulness in not being able to read, and so rather than admit they can't read, they'll say, oh, I don't have my glasses, or some other reason. And so it takes more work on the part of the attorneys who are representing that client to really dig in and find the deficits and be able to demonstrate those to the court.
Talk to me a little bit about some of the data, what the data reveals about people with intellectual disabilities. We're talking about race, ethnicity. I've read somewhere that is disproportionate as far as people, African Americans and Latinos. Can you talk a little bit about that?
To be honest, we haven't broken down the data by race, which maybe we should do, and maybe we can get some of that information to you. But I will say we see with the Latinx population, there is a lot of difficulty in that if they're not native English speakers, it's much harder to identify and figure out what testing to use for them. And then there is the challenge of state experts who might come in and say, well, we're going to adjust it based on their race or where they were born, and that tends to disfavor, a finding of intellectual disability. And so we have really worked to try and educate defense teams and find experts who are familiar with testing and evaluation in those populations. But it is definitely a challenge. I would say in the African American community, we find that perhaps the prosecutors will use stereotypes against them and say, well, maybe they can't do that, but it's because it wasn't expected in that neighborhood, or it wasn't expected of that segment of the population. And so really you see racial stereotypes playing a role in the state's presentation against an Atkins claim, or even a state's expert in an evaluation of an Atkins claim.
What do they call it? Ethnic adjustments,
right.
I think, something like that. So, but how do you? And I guess we get into, when we talk about that, we're kind of getting into the area of bias in a sense. How do you deal with that? When you have a prosecution team that is looking more at bias. You have a judge that is biased based upon their geographical area. How do you guys fight against that? How do you educate people?
I think when we are handling our cases within our office, we approach any intellectual disability case with the idea that we have to overprove our case. We know that there are going to be those types of biases, and that there are going to be non-clinical arguments raised by the state or even by the state's experts. And so we really work to identify as much information, as many witnesses, and have as thorough an evaluation as possible to present, so that we can always go back to that, and hopefully what we've presented in our own case will be sufficient to combat the biases and the just improper arguments raised by the state.
So let me ask you this question, and I hope I'm asking it right here. How has, I guess, the non-enforcement of Atkins, because the Supreme Court said, hey, you can't put these people on death row, they shouldn't be executed, but they're not, it doesn't seem like they're enforcing it with the lower courts. The lower courts have found different ways. And surely after the Atkins decision, they interpreted that to be, hey, we can set our own standards as far as how do we determine someone has intellectual disability. How has this non-enforcement, if you perceive it that way, been, kind of facilitated by the states and legislatures? How has that created like different obstacles for people seeking Atkins relief?
I think what we've seen in the data, because we review every case dealing with Atkins across the country, because of the allowance for states to define their own procedures and their own definitions, we found a real state-by-state variation in the success rate among Atkins claims. So for example, Texas had almost a 0% success rate in Atkins claims before the Moore decision struck down the Bresenio factors. And so the Supreme Court's allowance for the states to define intellectual disability for themselves really made it so that some states were making it almost impossible for clients to prove that they were intellectually disabled. Alabama has created a beyond a reasonable doubt standard, and so that standard makes such a high bar for people to be able to prove intellectual disability that their success rate is also very low. That certainly is problematic because we're looking retrospectively. We have to necessarily be looking backwards toward the developmental period. And sometimes you don't have as many witnesses or as much information available to be able to reach that high bar of beyond a reasonable doubt. Tennessee still has a 0% success rate because they have created so many procedural obstacles to people being able to even raise intellectual disability claims. Hopefully that will get better since they have changed their legislation, but we haven't seen that play out yet. So I think it really has led to state-by-state variation, which is a huge problem with the death penalty in general. You see that whether you get the death penalty is not so much dependent on the crime that you commit, it's dependent on where the crime is committed. And that seems to be very similar in the Atkins litigation.
Okay. So here's the big question. I've read data on this, but the big question I've always had is right now we have about 2,600 people on death row. How many of those individuals do we figure have ID?
It's hard to say exactly how many people currently on death row have intellectual disability, but we do track every single Atkins case. Over the last 20 years, we've identified over 600 people who have raised Atkins claims. And so there's a large percentage of people over time who have been faced with the death penalty who have an intellectual disability for the reasons that the Supreme Court created the Atkins decision. You know, they have a harder time working in the legal system themselves. You know, they may be more susceptible to peer pressure. You know, that seems to be, it plays out in these crimes and in these cases. We have also tracked how many people have raised intellectual disability claims but then have been executed. And among the cases where the courts have actually reviewed the merits of an Atkins claim, almost 50 people of that group have still been executed, and almost 10 over the last 3 years. So we're still executing people who are raising intellectual disability claims. I don't know the merits of every single claim, but they had at least enough merit to get past the procedural bars and to get a merits ruling on their case.
That's remarkable.
Mm-hmm.
So let me ask you this. In your opinion, why shouldn't we execute people with ID? How do you feel about that? What is your response to that?
Well, I have worked on a number of cases with people that I know have intellectual disability. You know, we have expert opinions that they are intellectually disabled, and having worked with them, I see that they are in fact more susceptible to being taken advantage of by other people. They are less able to cope with some of the stressors and problems that they're having in their own lives, which can result in committing a crime. They're also much less able to advocate for themselves in the legal system, in the prison population, and so they just are a much more vulnerable population than the rest of the people who are incarcerated and who are facing the death penalty. And so I agree with the Supreme Court's decision that categorically people who have intellectual disability are not the worst of the worst offenders and should not be the people facing the death penalty.
So, in your opinion, and I guess you and John and Emily have written about this, but you know, what are some of the considerations attorneys should keep in mind when they are representing someone with ID?
I think one of the main things that defense teams need to keep in mind is that you're dealing with something that could be embarrassing or shameful to your client. And so not because they're being deceitful or not because they don't want to help you help them, they're not going to be able to tell you that they are a person with intellectual disability. It's something that the onus is on the defense team to do the investigation, to make sure that their client is not a person with intellectual disability before they decide not to raise a claim, which means that in every single death penalty case, we need to do some level of investigation into intellectual disability. It's a categorical bar. We have to make sure that they are not ineligible for the death penalty.
Yeah. Do you think there should be a greater judicial or legislative commitment to enforcing Atkins? You think, or how do we cross the finish line here? Because we're seeing the trend where less and less states are, using the death penalty as a form of punishment. There are even a handful of states that still have the death penalty on the books, but they're not even exercising it. We see that, as far as the international community, less and less countries are using the death penalty. Right now, our country is in pretty bad company with Iran and North Korea. So, do you think we should have more commitment, judicially and legislatively?
I think there has to be a real commitment to following the clinical standards. The medical community has determined what it means to be intellectually disabled, but we see courts, the states, the government come in and raise arguments that are not consistent with the clinical guidelines to show that a person is not a person with intellectual disability, that they're using stereotypes, they're using... it seems like every time there's an advance from the Supreme Court saying we have to follow the clinical standards, we have to follow the current clinical standards, there is a push back to come up with some other argument for what, non-clinical argument for why somebody isn't intellectually disabled. And it creates a risk that we're going to carry out unconstitutional executions of people with intellectual disability. And so I think the whole legal system needs to be more focused on is this a person with intellectual disability? That should be something that the state cares about. That should be something that the defense cares about. And it doesn't need to be adversarial, win at all costs. It needs to be, we have to find the truth. And there are standards out there created by the medical community that will lead us there.
I think it was, we interviewed Michael Perlin, and he said that, he thought that our justice system in this case was all about vengeance. Would you agree with something like that, or do you think it's just because why wouldn't lower courts adhere to the Supreme Court and just follow what they said, and instead of trying to find different ways? Is it just this need for vengeance, just trying to get your perspective, or is it, hey, politics play involved or play a role in this? What's your sense of that?
I do a lot of post-conviction work, and so I see that once there is a death sentence imposed, it almost starts a snowball that it's so hard to stop. That the courts are reluctant to overturn a decision of a jury, even if there is clear evidence that a person has intellectual disability. Maybe there is vengeance on the part of the prosecutor who is defending the death sentence. I had a thought, and now it's slipped my mind.
Oh, it's okay. We can move forward, and then maybe like it seems like we're still dealing with this proceduralism, because I don't know anything about the law, of course, but isn't part of justice this whole idea of us searching for the truth, instead of looking at proceduralism, looking at, oh well, you didn't cross every T and dot every I. I'm having a hard time grappling that and dealing with that because, everything that I've heard, ever since I was a little kid, growing up, hey, it's about the truth. So it seems like, in this case, you could have a situation where the truth doesn't matter.
Yeah, I think that's right. I think that there are cases where a prosecutor makes a decision to seek the death penalty, and then it just runs from there. And the only goal of the state is to obtain and then defend that death sentence, regardless of what the truth is about intellectual disability. I'm litigating a case right now where we have that very thing. We have 4 experts who say this is a person with intellectual disability. No one is saying that he's not a person with intellectual disability, and the state is still defending it, coming up with more and more non-clinical arguments for why this may not be a person with intellectual disability. And I don't feel like it's the search for the truth. I'm hopeful that the judge will get to the truth, but there is, I don't think that it's a commitment from the state to reach the truth.
Yeah, and then you have situations like state of Alabama in the case of Matthew Reeves. I think their psychologist King even admitted that, hey, he has an IQ of 68. That's below the 70-75 range, and the state still decides to go forward with the execution. Talking with Matthew's mother. Interviewing her, she said, look, he got shot in the head. I forget if it was like a couple of months prior or whatever, but he was shot in the head, and there's no, it seems like, I guess you would call it mitigating evidence. Not being able to really fully examine that, because it seems like, the data shows that, trauma like that could bring forth intellectual disability, even though Matthew was over, age 18 or whatever. But isn't that a problem? Isn't that something we need to look at, you think?
Yeah, I think that's right. I think whether it's trauma later in life that causes the same impacts and symptomatology as intellectual disability, or whether it's severe mental illness that is making a person similarly less culpable, not the worst of the worst. I think it is a problem that we have sort of a double standard. If you can prove that you're a person with intellectual disability, you're categorically barred from the death penalty. If you have almost identical deficits because of mental illness or trauma or some sort of physical injury, you're out of luck. You have to go before the jury. You're not barred from the death penalty. And so I think that is more evidence of the arbitrariness of the death penalty system as a whole, and certainly a problem.
Yeah. So I think about, people like Lisa Montgomery. I think she was executed in 2020. Right before the inauguration.
Right.
And I read some stuff about her going through many years of trauma. I think, if I remember correctly, sparked by her husband and everything. And I mean, the crime she committed was heinous. It was, but there seemed.
Sirens.
Oh, sirens. Okay. They're after me.
Rolling.
Okay. It just seems to me that when you're talking about people like Lisa Montgomery and others, we kind of focus on what they did and not, okay, do they have ID? And it seems like judges and juries across this country, they get so caught up in, the act, the crime that they committed. Can you speak about that a little bit?
Yeah, I think that is certainly a problem with juries making decisions about intellectual disability. The question of intellectual disability is put to the jury after the guilt phase, after they've heard all of the aggravating evidence. And then they're told, well, if you find this person intellectually disabled, you cannot sentence him to death. And so it makes it so that the focus really is on the crime or whatever aggravating evidence the prosecution puts forward, influencing, I think, the jury's ability to objectively determine whether a person has intellectual disability or not. And so, yes, I think that there is a lot in this system that is set up to focus on the crime, not as much on the individual himself. And
So it seems to me that you would want to, like Emily said, with all capital cases, she tells clients, look, you have to test for this. You have to explore the possibility of intellectual disability. I think I read something. I think it was an article, ACLU. They were talking about their. Almost everybody on death row has some type of either intellectual disability or mental illness of some sort. But is there? I guess there's value in testing early in the process, or at least bringing that forth to a court before you get to after the fact, if you will. Is that something that a strategy that needs to be employed, you think, or
yeah, I think all capital defense teams should be interviewing witnesses around deficits that might be consistent with intellectual disability, certainly reviewing every record about the client that's ever been created. School records are incredibly important, but obviously there are other records where evidence of intellectual disability might show up. And use that kind of information to help guide whether and when to do IQ testing, because certainly that has to be part of an Atkins evaluation. But I agree. I think that if defense teams can present it prior to trial, either using it to negotiate the case with the prosecution before even getting to the court, that can often be helpful. We do track, though it's challenging, we are tracking cases that have been settled with the prosecution on the basis of intellectual disability. And there's a significant number across the country where you raise evidence of likely intellectual disability, and then the prosecution recognizes that, this isn't a case that we're going to capitally prosecute. But then if you can also get in and have the decision made before trial by a judge who hasn't sat through the entire guilt phase and aggravation phase, to be able to get a pretrial determination, I think is a much more objective and fair way to rule on an intellectual disability claim.
So, the Supreme Court has made it more difficult for habeas remedies and things of that nature. Can you talk about how that affects some of that Atkins, protection, some of the procedural hurdles, you could have an increased risk of wrongful conviction, state court rejections, all of those things. Can you speak on that a little bit?
Yeah, the limitations on federal habeas review really, they hinder defense teams from fully presenting valid claims that a death sentence is unconstitutional, whether that's ineffective assistance of counsel or an Atkins claim. And it means that if somebody missed intellectual disability along the way in state court, you can never have a federal court review it. That's basically where we are at this point. And so it just really renders a person much more eligible or susceptible to be executed wrongly when they are a person with intellectual disability. Sometimes state post-conviction teams are not well funded, don't have the ability to get a hearing, have a much harder time preparing and identifying the evidence for an intellectual disability claim. And if then you get to federal court and it hasn't previously been presented, you're kind of out of options to be able to raise it. And so it definitely is a problem in the Atkins area and also other areas of the death penalty. John Bloom probably explained it much better than I did.
No, but it's good to get different perspectives and everything. I love that. With your research, does it seem like, and I'm just throwing this out here, does it seem like courts are trying to get rid of or eradicate, racial prejudice in capital murder cases, or is that, to the contrary? I mean, what do you see?
I see very little grappling with the racial bias that plays into death sentencing and even evaluations for intellectual disability. I think courts don't want to rule on that issue, and so it is a challenge for defense teams to figure out how and in what ways to present what we know is happening, the bias that we know is happening in the system. Decisions from the U.S. Supreme Court, like McCluskey, have made it almost impossible to prove racial discrimination in capital charging. I think that trickles down into how do we deal with racial bias as it plays out in other parts of the criminal justice system and how it plays out in Atkins cases.
That's interesting because we all know it's an issue,
Right.
But it's almost like they're saying, "Oh, we don't want to touch that."
Mm-hmm.
I don't see anything. I don't see anything.
Right.
I don't hear anything.
Exactly. Right.
Yeah. Okay. My notes here. So what else can you say about states that define and evaluate people differently with ID? What else can you say about that as far as how it affects or impacts Atkins cases on the ground,
Mm-hmm.
In the different states across this country?
Well, I will say one positive thing. In Texas, I have seen the Court of Criminal Appeals actually say we need to take a second look at some of these cases now that the standard has changed. Now that Bresenio has been struck down, they have sent a lot of cases back to the trial courts to actually litigate and decide on intellectual disability. And they have very quickly increased the number of people that have been removed from death row because of intellectual disability. I think those are a lot of people who very clearly had intellectual disability, but when you were using the Bresenio factors as the measuring stick for whether they were a person with intellectual disability, you couldn't prove it. But when you actually faithfully apply the current clinical standards, they have found a good number of people intellectually disabled and reformed their sentences to life without parole. So I think there is some good happening on the ground. We've seen in Tennessee they've changed some of the procedural mechanisms, and so people are hopefully going to actually get a full and fair consideration of their intellectual disability.
That's amazing in Texas because that was
I know,
called
right?
the execution capital of the world at one time.
Yeah, I've been surprised how many cases you see the Court of Criminal Appeals just says, yep, the trial court found that they were intellectually disabled. We've reviewed the record. We agree. Life sentence.
Wow.
So yeah, that has been a massive trend and increasing the success rate that we've found since the Moore versus Texas decisions.
It just seems like Oklahoma is kind of challenging for that title now.
Mm-hmm.
They got a lot of executions
Yeah.
lined up.
Yeah.
I was shocked.
Yeah.
Yeah. Can you, when we're talking about assessing people with ID, how important is it to get qualified experts? I know, like, sometimes there's this, I think I was reading, watching some video, they're talking about people that were ID experts, but then clinical psychologists reviewing or assessing
Mm-hmm.
people, and there's some difference, and they don't always see eye to eye
Mm-hmm.
because they come from a little bit different backgrounds. But can you talk about how important it is for attorneys to find good quality, credible psychologists, experts?
Mm-hmm.
I should just say experts.
Experts, yeah.
To help them assess.
It's incredibly important to find a qualified expert, an experienced expert, an expert who's willing to take the time to fully review the records, to do interviews with people who knew your client, to interview your client, to do the testing that's required. I think it goes back to what I was saying about we have to overprove our cases, and so we need to have the best experts who are going to go the extra mile to be able to fully present the case for intellectual disability and be able to combat whatever the state kind of comes back at them with. We often use more than one expert because there could be an expert who is much more comfortable or has more experience with evaluating adaptive deficits, or more experience with the psychometric parameters for the IQ testing. And so sometimes combining experts can be really helpful in our cases. But I really think that the most important thing is to have an expert who's going to look across your client's entire life, talk to as many people as possible, take in all of the information, and compile that into a really robust evaluation of intellectual disability. We have to be able to tell a story of this person's life, and the experts are really able to do that through a really thorough evaluation.
And my last question is this, because I know you got to go.
Yeah.
What have we missed here? What haven't I asked you about? Is there something else that needs to be presented in this argument for people with ID that are facing the death penalty? Anything that you can think of?
Not that I can think of.
Okay. All right, cool.
Great.
Good.
Anything else? You good? All right. Well, I think that's it.
Great.
And I
Thank you.
appreciate your time.